Good morning, distinguished Rotarians. Welcome to the Advanced Conflict Resolution course organized by the Rotary Action Group for Peace Nigeria chapter. We're all excited to have you here for this very important capacity building workshop. We recognize the presence of PDG Alison Sunderland, cadre advisor and past chair of Rotary Action Group for Peace International. We also recognize the presence of our very distinguished facilitators, Rotarian Frederico Antich and Rotarian Zephaniah Ongara Mochoge. Recognize the presence of board members of the Rotary Action Group for Peace Nigerian chapter, Rotarian Dantatandus, and other high-ranking officials. The National Legal Advisor is here, Rotarian Ihoma. Peace zonal coordinators are here, Rotarian Saidu and others. You are highly recognized. We recognize all members of the Action Group chapter, all Rotarians and Rotary associates, very distinguished peace builders and peace lovers in Nigeria and beyond. You are welcome. At this juncture, I would like to invite PDG Alison Sunderland to please give us a remark on behalf of the Rotary Action Group for Peace International and declare this workshop open.
Thank you so much. It's always such a pleasure to meet with you, and it's a huge privilege to be representing the RAG for Peace today and to be speaking here and to be using this Zoom. So thank you all that you've dedicated this time to this learning session. Thank you all for your hunger and thirst for knowledge, for tools, for skills, for peace building in your country. I just think that this will be a stepping stone, because I know that Pietro and his team on the board, on the chapter, have great things planned. And I think you as a chapter will be able to share much with other chapters, and perhaps in due course you can share this knowledge and help them grow so that globally it mushrooms, and that we share our knowledge and our passion. So I have great privilege in declaring this training session open. Thank you, Pietro.
Thank you very much, PDG Allison, for those remarks. Indeed, there's more in sharing and learning together. Thank you so much. I want to quickly invite the Executive Director of the Rotary Action Group for Peace Nigeria chapter to give us a remark as well. Rotarian Dantata Mohammed Ndus. Please, you have the floor, sir.
Thank you, my chair. Thank you, PDG. Thank you, everyone that is on the call this morning. We hope to be enriched once again, and we hope to get more knowledge. I trust that by the end of this capacity building, we'll be ready to go in and out to make sure peace is sustained in our environment, communities, and of course, our country and the world at large. Thank you and good morning.
Thank you very much, my capacity ED. Very distinguished Rotarians, you are welcome once again. Let me quickly run through the housekeeping rules in case any of you might have missed it. It is very important, of course, that we familiarize ourselves with these rules and be sure to follow it comprehensively so that we are not surprised at any juncture. So for starters, we request that you be on time, and we thank many of you that joined on time. Secondly, decorum is key. To that regard, we request that you constantly keep your mic muted till we get to the Q&A session. The facilitators would advise on how to handle that, whether you communicate via chat or mute and ask your questions. Also, if you are given the opportunity to speak, please communicate professionally and use censored words, of course. Most of us are Rotarians and professionals, so we know what's obtainable. We also request that you leave the meeting at the appropriate time. And if there's any need that you might leave early, please leave a message. Attendance is very key. We take screenshots at intervals for documentations. This is a certified course, and there are criteria to meet for certification. Attendance is one of them, as you already know. Many of you have taken our courses severally, so we'll be taking rounds and be recording these attendance. Most importantly as well, I would advise you show your face, but if your environment is not conducive or your network is not strong enough, please, you can leave your video off. And to the keynotes and compulsory ones, there'll be examinations after this training. Usually our trainings are attached to examinations. So this is no different. So we advise you listen attentively, take notes. We'll email you all the presentation slides at the end of the training tomorrow. Also of importance is the IEP Positive Peace Academy course. It is mandatory because we must cite it during your grading to ensure you meet the criteria for certification. Thank you once again. At this juncture, I would like to now introduce our first facilitator for today. Our first facilitator is a seasoned peace builder by name Frederick Antich. Frederick Antich holds a law degree from the University of Florence and an LLM in US and Global Business Law from Suffolk University Law School in Boston, USA. He's a practicing attorney admitted before the highest jurisdiction in Italy with over 25 years of experience. He has successfully handled national and international contracts, civil and commercial litigation, and has pioneered the practice of dispute mediation in Italy, having mediated over 5,000 proceedings since 1999. He is currently accredited as a mediator by several bodies, including internationally the CEDR in London, the ICMC BRI in Beijing, and the IMI in The Hague. He is registered in the list of mediators established at the Ministry of Justice pursuant to Ministerial Defense 150/2023. Veteran Frederick was the first Italian to be accepted as a distinguished fellow at the International Academy of Mediators and currently serves as president of the Italian delegation of the Mediation Center for Europe, the Mediterranean, and the Middle East, as well as a member of the advisory board and past co-chair of the IBA Mediation Committee. In 2020, he was awarded emeritus status at the World Mediation Organization. In addition, he's an affiliated professional of the American Bar Association and a member of the Chartered Institute of Arbitrators. Since 2003, he has been teaching and training in the theory and practice of non-contentious dispute resolution, having obtained certification as a trainer of trainers in mediation from CEDR, Mediation Works Incorporation, and as a trainer in higher education from the Derek Bock Center for Teaching and Learning at Harvard University. He is enrolled in the list of trainers established at the Ministry of Justice pursuant to DM 150/2023. He has lectured on mediation, conciliation, and negotiation at the University of Florence, School of Law, School of Economics, and Political Science, and at the University of Siena Sola, Superiore per lo Professional Legale. Thank you very much, Rotary Federico. It's a pleasure to have you, sir.
Thank you very much indeed, Pietro, and good morning, good afternoon to everyone here. Thanks a lot for hosting me, and thanks, of course, the Rotary Action Group for Peace for both the international and the regional chapters to allow me to speak today. My aim here is to provide you with a sort of a small talk about the concept, methodology, and practice of ADR. And as a facilitator, I've been asked to in some way facilitate the understanding and the application of those tools of to be employed as methods to resolve disputes or quarrels. Okay, in doing this, I will try to, if I can, share my presentation with you. A very short one, believe me, it's unlike my CV, it's very short. And I just give me a thumbs up if you can see it. Thank you, Alison. Thank you all. Great. So briefly, here I am. And my first task is to introduce you about the real of alternative dispute resolution, okay? ADR, this very nice and still appealing acronym. It was envisaged in the early 70s in the outside and out there in the Atlantic Ocean in the United States, and then was spread over throughout the world. What I can tell you is that actually when we are talking about ways to solve disputes outside of the courtroom, which is the typical definition of ADR, this is something definitely not new in many, many countries, okay? I used to play in my courses that mediation for me is the third oldest business in the world. And you can probably think about what are the first and the second one. But the third one is the sense that actually you need at least three persons to mediate. And when all three persons, or at least the one person who fight the other two that are actually fighting one against the other, the third one may realize that if one of them can got ill or in somewhat limited in his work, they cannot operate anymore as a group. And that can perhaps provide some problems and issues for the three of them. So it's better for him not to just sit down and enjoy the quarrel or enjoy the show, but better to step in and try to understand why the two others are fighting one against the other, and discover probably that kind of quarrel came out of a misunderstanding or something very, very similar to get for one party or the other. So with his intervention, the intervention of the third party, the group can avoid the quarrel or settle the dispute and come over and become more resilient, okay? So this is something that happens in every place of the world, and I'm very aware that in Africa as well, there is a very, very long tradition of employing different methods of solving disputes outside of the formal courtroom, okay? It's the same in Italy, it's the same for Alison in Wales, England and Wales, and other places. So just to provide you with an idea, I took the liberty to mention this old saying that is in Yoruba language, which is something probably familiar to many of you from Nigeria, which should be translated as follows. Litigants do not return from the court and remain friends, okay? It resembles also of other Christian saying, etc. That is, it is meant to remind people that quarrels can happen and they can even solve informally in court, but very seldom that kind of solution is something that really satisfy all the people involved. Okay, so the concept around ADR, the acronym that I mentioned, is alternative. Okay, so alternative to what? Alternative to the typical way of solving disputes, that is the formalized one, the one that says if you want to solve your dispute, it's better to record to a judge because he or she is more acquainted with the law, and the presumption is that that kind of dispute must be treated within the boundaries of the law. So who better than a judge can decide who is right and who is wrong applying the law, okay? So the concept was developed, as I said, in the early 70s in the United States. And the idea behind that was that the traditional approach to solving dispute, that is going to the courtroom, was not very efficient. It was extremely expensive. And moreover, the issue was that parties in doing so would lose control over the outcome of the dispute, because actually they are just bringing the dispute to the court and wait until the court will decide how to manage that dispute in allocating the rights and wrongs of the people. So even outside of the concept of whether it is acceptable or unacceptable as a party to a litigation in court, the important thing to consider is that at that time the parties are just waiting for a third person who has nothing to do and nothing to say about the actual case, but who is in charge of deciding about the outcome of that case. And this could be probably acceptable, at least palatable to some people, especially people who don't want to get responsibility over their own actions. But it's definitely not appealable to those people who instead prefer to take care of themselves and have control about their lives and about even the management of disputes with others. So this alternative was there to say, okay, there is not only the court. What kind of other methods are available to employ in order to solve disputes? And this question has its own importance to offer. That is, the importance is to reduce the court backlog, because if you only provide courts to the people, then the people are there and asking the courts for redress in even the very, very minimal cases, okay? Let alone bigger ones or more complex ones. The alternatives can be palatable if they can save time and money, at least with respect to the formal litigation. And what it was discovered is that there are actually methods that are more time-saving and more money-saving than going to courts. And also, which is more disruptive, I would say, on the psychological level, those kind of alternatives are there to change the mind of the litigants, in the sense that instead of just competing one against the other, they have to start collaborating one with the other. So instead of just saying, I want to fight and get a sort of I win, you lose kind of approach, they are trying to convey this other completely different concept, that is, we come together, think about and discuss about the ways to solve the matter that ties both of us together. And working together, we can collaborate and find a viable solution that is okay for both of us. So it's a sort of win-win kind of solution, because both people are okay and feel okay with the possible outcome that they elaborated together. So this is the third thing that I want to let you consider when introducing the concept surrounding the acronym of ADR. Then when you go more in depth about the concept of ADR, there are several of them, more pretty formalized. The typical one is just direct negotiation, one-to-one negotiation. Instead of just asking someone else to decide on our behalf, we can sit, if you want, we can sit down and discuss. Okay, direct discussion between the parties with the aim to reach a mutual agreement. This happens, I mean, every day. As a professional, I can tell you, but not only as a lawyer, there are probably some of you who are chartered accountants or others, and for them it's the bread and butter of the profession to have people coming to their office and asking for assistance in trying to negotiate contracts, or even to prevent or to solve already exploded disputes. Okay, so direct negotiation is a typical one. Of course, as the Brits would say, you need two to tango. And of course, for a direct negotiation to be effective, you need both parties to be willing to sit down and to discuss in good faith and try to find together possible ways of mutual agreement. Otherwise, negotiation would fail. Which is why, by the way, mediation came out. And mediation is a sort of negotiation with a twist, as I like to say, in the sense that it's just like a regular negotiation, but this time parties are not let alone. So sometimes parties can destroy negotiation or go out of the negotiation table because at some point there is a sort of blockades, or one party becomes to be dissatisfied with the other. So there are other elements that come into account that can be disruptive in the exchange of information. So the presence of a mediator who is a third party neutral, a person that on one hand is independent from each of the parties at stake, but at the same time is a sort of a learned person. So is not just the man in the street of the average person. It's instead a professional who has studied mediation in the formal courses, has experience as a mediator, so is probably put in a better condition than the average person, probably, to help parties work on that negotiation. So provide a sort of facilitated negotiation, where the facilitating part is sometimes to act as a sort of a shuttle, going from one party to the other, exchange ideas and views, sometimes be a sort of the devil's advocate of one party. So the possibility for one party to have a sort of confrontation in a secluded part of the mediation table outside when the other party is alone. So it's what is called in a caucus session or a private session. That party can have a sort of frank conversation with the mediator, and the mediator sometimes is there to help her to figure out what would be the possible alternatives, what actually, if she decides then to go to court, what would be the possible outcome in positive and in negative, how much of the percentage of finding a favorable decision in court if she doesn't want to settle that case in mediation. So it helps a lot, a mediator, into negotiation. So negotiation is typical one, then mediation for most of sophisticated parties. Conciliation is a sort of mediation in the sense that, unlike mediation, where the mediator usually is there just to typically to provide facilitative work, that is, the one who does not judge the opinion of the parties. Instead, with conciliation, the third party is there not only to listen to the parties, but also to issue a formal proposal to the parties, okay? Of course, that proposal is not binding, usually, but it is something that is typically or customarily taken in serious consideration by the parties. So if they want to abide by the terms of the conciliation, fair enough. Of course, if even one of them is not comfortable with accepting proposal by the conciliator, then of course that party does not settle, and of course the case will not settle. Nonetheless, there are a lot of examples throughout the world, and even at the ICSID level, so at the international level, the ICSID is the International Convention for the Settlement of Investment Disputes, okay? That over there, recently, they moved and provided new rules on mediation, but until then, until a few years ago, direct negotiation and conciliation were the two major ways offered by ICSID and from the court, International Court for Settlement of Investment Disputes, to offer to the parties who were in disputes, whether it be states or investors, etc. This, of course, outside of the more typical way of solving dispute outside of the courtroom, that is arbitration, okay? Here, the third party, just like the mediator is there to listen to the parties in dispute, which is okay, but now the things change a while. in the sense that with the arbitration, just like with the regular courtroom, the trial court, etc., the scope of the arbitrator or the panel of arbitrators is there to issue a binding decision. It's called the arbitral award. And the arbitral award is just like a regular decision in court. So it may be directly enforceable, okay? So actually what changes with mediation arbitration is that the third party is there, okay, but in mediation, third party has no power to decide who is right, who is wrong, because it's not his job, okay? His job is to help parties find a mutually acceptable agreement, which is totally different from issuing a decision on who is right and who is wrong. Instead, this part, the decision, is this job one of the arbitrator, okay? And it's important to take this into account, because when you change from mediation to arbitration, sometimes you can even look at contracts or standard contracts and standard clauses that contain one or more of these types of so-called ADR. And we have to be careful in employing them. Sometimes they are even issued in a sort of a compilation-like list, okay? And you have clauses, dispute resolution clauses in contract that are called neg med arb clauses, okay? So you first try negotiation for a certain amount of time, and if that time expires, then parties are requested to go to mediation. If the mediation fails, then the parties go to arbitration, okay? So this just to provide you with a general overview of the types. Benefits of ADR. There are pros and cons. Of course, ADR, mediation, conciliation, negotiation, even arbitration are very powerful tools, but they are not a panacea, okay? They're not a treatment for every kind of illness. There are pros and cons. What are the pros? The benefits of ADR. First of all, confidentiality. The proceedings in ADR, especially mediation, is covered by confidentiality. And this preserves reputation information, which provides a sort of a safe harbor to the parties, even to exchange sensible documents, because those documents, when they are indicated as confidential, they may be employed within the mediation, but cannot be employed outside unless there is express will of that party to disclose them. Okay, and what is interesting is that in the last 30 years there was a growing interest on this part of confidentiality, to the point that many states are enforcing their own laws, the confidentiality provisions. Okay, whether stated by the parties in the contract or by referral to mediation rules of some mediation provider, for instance. It's the case for Italy, for example. In Italy, you cannot ask the mediator to testify over what he or she has heard during the mediation sessions, because they are covered by confidentiality. It would be inadmissible in court to provide that kind of testimony. The same for control. I mentioned you before. Parties in mediation, mainly mediation, but also in conciliation, have great control over the resolution process and outcomes. Okay, unlike in court, and of course with the exception of arbitration, as I said before, for mediation mainly and conciliation, parties retain control over the outcome. Okay, and this is interesting because there are another great movement that I observed in the last 30 years, that is a movement toward mandatory mediation. Okay, even the UK eventually joined in some way, of course, in their own style. Alison, please allow me.
Of course.
Yeah, as usual. In a very famous case of a couple of years ago, Churchill versus Merthyr Tydfil. That is actually a place in Wales, the Bureau of Merthyr Tydfil. And that is a leading case that was there to allow, even in the UK, the possibility for courts to order in some way the parties to go to mediation And that was something new, at least for them, because up until there were different views in the case precedents, but the general idea was that courts could only invite parties to go to mediation, not order them to go there, and even stay in the proceeding and wait until the parties come back if once they have tried mediation. So there is a big movement towards mandatory mediation, and Italy is probably one of the number one of those countries who adopted the so-called Italian model of mediation. Is very much relying on mandatory mediation, both as a legal provision and as a court order. But the point is still there is that mediation is a voluntary process, and the check of what I'm saying, so the absence of any inconsistency within the two terms, mandatory mediation of a voluntary process, lies just in the fact that parties are obliged to sit down and listen to what the mediator has to say to them and eventually participate in good faith in negotiation. But they are not forced in any way to settle the dispute. Okay, so they still retain control over the outcome of the mediation itself, and which is important, okay, because we're not arbitration, this is not judicial proceeding. Speed, it varies a lot, okay, even at the practical level. And generally, and in my country, for instance, now it may take a little more, but let's say it would be fair to say that a mediation would last for 30 to 60 days or 1-2 months, okay? It may last in a few hours, believe me, sometimes a couple of days. But on average, there are people that tend to express a lot about the subject matter of their dispute in mediation. Sometimes you need expert witnesses or technicians who step in and provide some extra information to the parties necessary to decide the case. So let's say on average, it would be fair, in my opinion, to say that in my country, 30 to 60 days would be an average time for mediation to take part. Compared to the minimum 3 years in trial court, that is for court of first instance, you can easily understand what I'm talking about and why speed is actually of paramount importance in mediation, can provide an important difference with the traditional litigation. It's probably the same in arbitration, okay, believe me, because sometimes, especially at the international level, many arbitrators are recurring ones. People want to rely on them, and they're a sort of a small enclave of very well-prepared and well thought of arbitrators. And of course, their agenda is limited by the 24-hour rule, which means that in a day you only have 24 hours. And sometimes even to allocate one of them for your case in arbitration would take you a long time in order to have your first hearing, because their agenda is already full for the next 4, 5, 6, 7, 8 months. So even for arbitration, it's not a quick way to solve disputes, just like litigation. For mediation, can be different. It really can take a very, very short period of time. Cost effectiveness, I mean, I don't know the tradition in Nigeria, but I can tell you, even in Italy, mediation compared to litigation is definitely cheaper for by any means, even if you employ the services of a lawyer to assist you as a party at the mediation table. Litigation, it's not very expensive like in other countries, for instance, in the United States. Of course, United States, by the way, I don't know if you know that, but there is a so-called American rule, which means that whether you win or you lose a case in court, you have to pay your own lawyer. So legal fees are on you in any case. In the UK, you know it very well, Alison, there is the so-called British rule, which means that it's the same like in the US, but if you apply to the judge after he handed down the decision, and you apply for costs, this judge may decide and rule in favor of you with costs, either in full or in part. And sometimes the judge will take into account also your behavior with respect to mediation that you were asked to embark during the litigation. In Italy, no. In Italy is whether you actually, if you win, you can get even almost 100% of your legal fees. But many times the judge set off. If the judge sets off your expenses, then probably you are familiar with the concept of a Pyrrhic victory. Okay, you win the case, but you lost your purse because you have to pay more money to your lawyer than what you could get or recover from the other party, especially when the other party is a commercial company that got bankrupted in between. So you have nothing to recover. Okay, so just a few tips to consider. I said pros, there are cons, of course. And there are disadvantages of ADR, like the limited scope of remedies. If you need something upfront, if you need to apply for an injunction, you cannot ask for an injunction to a mediator, of course. You have to go to court, even in between if necessary, if this is necessary for you to prevent the disruption of the loss of your rights, okay? So there are limitations, of course. And this is more evident also in the enforceable domain, the enforceability issues, okay? Because in many countries, the MSA, as say in the display here, so the mediated settlement agreement, the agreement that derives from a settlement reached at the mediation table, is generally considered as a contract. And as a contract, if it needs to be enforced because parties don't want to, or one of the party changed her mind at some point, and one did not want to enforce the terms of the settlement agreement, then the other party has to go to the court and say to the court, please court, this is a contract. The other party is in breach of that contract. Please order the party with a final decision to abide by the terms of the contract. And of course, this can take time, money, etc., etc. Luckily enough, there are countries just like Italy, for instance, that provides that when parties reach an agreement in mediation, this is an enforceable title per se, which means that that agreement can be enforced with the power of the law directly to the other party. And this is even more important at the international level, because recently you have heard probably about the Singapore Convention of 2019. And it's interesting to know that up to now, in January this year, there were 57 states worldwide that are signatories to the convention. And recently, less than 2 months ago, Costa Rica was another state to become the 18th contracting states of the Singapore Convention. The Singapore Convention is important because it just focused on the circulation of mediated settlement agreement around the world. So you can see that two countries for instance, of two parties of two contracting countries have reached an agreement. That agreement can be easily, according to the rules contained into the Singapore Convention, be enforced in the other country directly without applying for sort of a new judgment in the enforcing country and asking the judge to consider the agreement as if it was a contract like originally and in many other countries not part of the Singapore Convention still consider. Okay, so the enforceability issues is another element important, and the power imbalances. Okay, so sometimes, as I said, mediation is not a panacea. It's not something for everyone that will cure every kind of diseases. The mediator is not there to provide balances where there are differences in the different power, knowledge, etc. of the parties. This is evident, for instance, when you have disputes that involve a consumer on one hand and the business on the other, okay, C2B kind of cases, where the consumer probably has not much knowledge about the issues at stake, probably some year ago, some time before, read the contract probably, but now the lawyer of the business entity is more prepared and has more grits on the issues and is actually, patronizing the consumer. Of course, the mediator cannot take the part of one side or the other because he or she has to be and remain independent. Nonetheless, this power impair can happen, and sometimes the mediator has to be aware of this and perhaps at least provide some time to the feeble party to consider, become aware of this power imbalance and try whenever possible to intervene and provide some kind of, look for some kind of support from other parties, just like, for instance, consumer protection associations or lawyers, okay? There are even pro bono lawyers who can act to support the feeble party at the mediation table in this kind of instances. The methodologies. There are the most common one, okay, negotiation. Probably many of you probably are aware of the so-called program negotiation at Harvard Law School. And the program negotiation of Harvard Law School, after the last 40 plus years, has provided a sort of benchmark in the domain of both negotiation and mediation, okay? So even the typical distinction, conceptually speaking, between the interest-based and positional negotiation is something that was created and developed conceptually by Professor Roger Fisher and other members at Harvard Law School, okay? So it's not much to say about this. Even in mediation, Harvard had its own say on mediation. I prefer instead, thanks to Alison, to use a UK approach, which is the one from the CEDA, the Center for Effective Dispute Resolution in London, that provide a sort of 5 steps in mediation. So mediation provides, looks for a preparation, the opening statements of the mediator and the parties, then a joint discussion, possibly private caucuses or private sessions with only a mediator and one party without the other, of course, all covered by confidentiality, and then the resolution of the outcome, okay, the conclusion of the mediation stage. Same for arbitration, okay? Arbitration, typically there are a lot of arbitral institutions, okay? Very well developed around the world, especially since the end of the Second World War, from the 50s of last century onward. There are more and more growing number of arbitral institutions that provide their own rules on how to handle disputes via arbitration, and sometimes they can settle a so-called arbitral panel, a group of 3 arbitrators or 5 arbitrators. Some other, they provide a so-called fast-track arbitration with just 1 arbitrator, and possibly using only documents instead that listening and to deposition of witnesses and others. But it depends. What I want to consider for you is that there can be so-called ad hoc arbitrations where parties decide what would be the rules of the arbitrators to follow, and there are instead administered arbitrations, that is, arbitrations that are conducted according to predetermined rules managed by institutions. That could be at the local level, at the national level and international level. The ICC in Paris, the International Chamber of Commerce, the Stockholm Chamber of Commerce, the London Court of International Arbitration, and the European Court of Arbitration are just a few of them as an example for you. The process of ADR, it's quite simple. There is an initial assessment, which is important in order to determine which ADR method is appropriate based on the dispute. And this resembles of the old idea of the multi-door courthouse. There was a concept developed in the 70s United States with the so-called ADR movement. The fact that people should go to court, but once in court, they would not be directed only to the room of the judge. There would be a clerk and the people will start talking to the clerk, expressing their own, explaining their own issue at stake, and then the clerk would be there to suggest them different ways of handling the dispute. So it's important now for all of us to consider which type of dispute management would be most appropriate for the kind of dispute we have at stake. Then the other point is selecting the good idea professional. At the international level, it's not uncommon to find parties, even sophisticated parties, big corporations, etc., who actually embark in a mediator or arbitrator's interview. They want to know in advance what kind of experience one has in the specific case at stake, whether there are any incompatibilities with one party or the other, direct or indirect, etc. So it's a small world, so people want to know whether the kind of third-party character is really one that it's there or it's just a formality. Then you have to prepare. Prepare is paramount, okay? Is prepare for the mediator and prepare also for the single party and her lawyer at the mediation, or as well as in arbitration or other cases, okay? It's important to gather documentation in advance, define their own interest, setting goals. Once there, it's important to consider that you cannot be a passive element, a passive person. You need to be an active one, okay? You are there to manage, you have the opportunity to discuss your issues and to convey what are your interests at stake there, okay? So you have to listen to the other party, explore creative solutions, okay? While remaining actively engaged throughout the mediation, okay? And of course, the follow-up. It's not important to reach an agreement. The important is that that agreement will be possibly voluntary enforced by the parties. Otherwise, the party will say, I reached an agreement, then I change my mind, and the agreement is rubbish. Okay, definitely not. So if the agreement has to be reached, it must be a thought one where the parties are convinced that it was in their best or in their own best interest to reach that agreement and pursue the obligations and rights included in the agreement. Best practices, okay? This is for us. Selecting the right professional is important because it's important to ensure the qualification and neutrality of the party. As I said, there are ways to interview a prospective third-party neutral, like a mediator or arbitrator, before he or she will be employed or appointed. Preparing effectively, as I said, it's not easy. Sometimes we don't have time. This is one of probably the worst mistakes that we can do. Okay, the lack of effective preparation. We instead have to clear in our mind what are our objectives and what kind of documents are relevant to provide during the discussion at the right moment, okay? The good timing, as the English-speaking people would say. And of course, fostering open communication. It's important to not consider mediation just like as a formality on the way to the law courts, okay? This is even more important where in countries like my country, in Italy, where actually effective 30th June of 2023, the same law asked the parties to cooperate in good faith and loyally in order to set up an effective discussion on the issue subject to mediation, okay? So it's important to consider that by now, countries like Italy, for instance, but probably in other countries is pretty much the same, the duty of the parties and their lawyers is not just to sit down at the mediation table and listen to what the mediator has to do to them, but it's also to engage in good faith and act loyally to provide an effective discussion on the issues at stake, which is a step over, okay, more important and more engaging, okay, and this is relevant, okay, like unlike it was in the past, where really sometimes mediation was considered as a mere formality on the way to the forum, okay. And of course, the other part is being open to solutions, because you are there as a party to look for solutions. Okay, you are there to engage in a discussion that is aimed at providing a panoplia of possible solutions. Then filter them, put them in a funnel, and distill the best solution that would fit the most of your own interest, while at the same time reaching the most of the other party's interest. Okay. And there are main case studies. Now, there's no time to discuss in depth many of them, but you can really understand or in your own experience, personal, professional ideas and situations where an effective negotiation resolved the troubles that came out of a contract, or in a business dispute where our parties, even big corporations that settle their disputes by way of mediation, or other situations where, for instance, even arbitration is more and more employed. I don't know in case in Nigeria, but in Italy, for instance, very recently, a few months ago, another law entered into force that actually asks in all insurance complaint cases to record to arbitration, which is interesting because the typical way, especially when you have situation where you have one consumer on one hand and the insurance company on the other, so even where the imbalance is very high in terms of money at stake, etc., actually there is this possibility that law says, no, before going to court, you go to arbitration. And the arbitration, of course, it's an interesting way, sometimes effective, but the consumer does not retain control like mediation, and the expenses may not be the same as in courtroom. Sometimes they're even more expensive than in courtroom, and the possibility to retain some sort of control, as I said, on the outcome is very, very limited. So arbitration is a very important tool, but we have to see whether one day it will be able even to take over the litigation, as some young students from Harvard are publishing in these few days and are available over the internet. Probably you have seen this, thanks to the development of AI. So the possibility to create a sort of arbitral courts already embedded with AI, and have an algorithm to decide instead that a physical person or a human being. Okay, so we will see probably more development about this, about the arbitration, but this was just an example that I wanted to mention to you. Of course, it would be important to analyze the outcomes of each of them, of those three examples, to see how to enrich them and let them be more and more effective and efficient. So to recap, and I'm reaching the end, to recap here, it is important to understand how ADR can be crucial to exercise an effective dispute resolution for a country and for the society at large. There are a lot of different methods, okay, various methodologies, a lot of different methods to exercise control and flexibility over the management of a certain dispute. ADR are options. They are there to be employed, and probably in your future experience, you will be more and more keen to ADR tools and methods. I would predict, especially mainly mediation and arbitration. If it is viable, well, I can tell you, ADR is a viable alternative to litigation, to formal litigation, because now is well structured, is known, is applied in many, many countries. Of course, each country has its own way of considering ADR tools, especially mediation. And of course, this is linked especially to the, how can I say, let's say I would say to the politics, but in reality it's a different animal. It's the culture okay, the culture of that country. And sometimes I see, especially US colleagues that are there in India or in Africa or in Southeast Asia pretending to teach to the locals the nuts and bolts of the Harvard negotiation and mediation way of managing disputes, only to discover that the locals are even more prepared to handle effectively disputes by way of mediation, even though they knew anything, knew nothing about Harvard before. So the point here is that, as I said at the beginning, each country has its own knowledge and culture of mediation. Okay, there are wonderful and marvelous mediators who have the personal touch, I would say, the personal touch to handle effectively a dispute and to help the parties reach an agreement. Okay, if you go to China, I'm sure even in your country, Nigeria and others, you don't necessarily need the Harvard way or the Harvard model. Okay, probably it would be interesting for you to enlarge your culture by studying that kind of model, but mediation is not something that is far away from your own personal culture. Okay, if you use them, it will be helpful because probably you will be even more effective. And in a world that is shrinking day after day, you will probably end up meeting people that are coming from different cultures. So sometimes knowing, being aware of concepts and how to handle cross-cultural disputes by way of mediation, it would provide you with even more tools, okay, in your basket. Having said that, I would like to end my presentation here and leave time for Q&A whenever possible, of course. Pietro, I leave the mic to you by now.
Pietro, I've noted a few questions in chat. Would you like me to voice them?
Yes, please go ahead, PDG.
Okay, so the first question, Federico, thank you so much for that. Suppose the ADR system doesn't work because both parties don't agree. What is the next step?
Interesting question. Of course, the ADR is usually a voluntary process, as I said, which means that you need two to tango. So both parties should agree. And sometimes this does not happen. If the parties are related together, for instance, because they are both parties to a contract, if the contract contains a clause that is a dispute resolution clause, which asks or calls for a mediation before going to court, then the parties are obliged to try mediation. And for instance, in my country, in Italy, if the judge discovers this kind of clause, even if the parties did not apply originally for the mediation, the judge can stay the proceeding for a while and order the parties to go to mediation according to the contract and come back only if they could not settle. Okay. Out of this, there are other situations. For instance, as I said, in Italy, the Italian model of mediation contains legal provisions that says that in certain areas of disputes, real estate, condominiums, and the likes, other numerated areas of legal disputes, you cannot go to court unless you first try to mediate your case. Okay. And again, the third element is the judge can decide on his or her own to send the parties to mediation because he or she thinks that they will be best suited with a settlement agreement rather than embarking in a full-fledged litigation. Okay, this is a power of the judge to do so. Of course, I'm aware other countries can think differently, but I can tell you at the Mediterranean level, there is a sort of a copycatting situation that is happening right now. From Italy, it moved to Turkey, And I've heard that recently even Spain has adopted new laws that would call for mandatory mediation, just like in Italy. Okay, so be aware.
Okay, Frederick. Alison, I think you should take the whole questions so he notes them down. There are lots of
Yes.
questions actually. Yeah.
Okay. So the next question is, and I'm going to give you all three together because
Please.
it's from the same person. Can we say arbitration is ADR same as legal process? Does it have a compelling and compulsory enforcement like a court judgment? And is legal representation necessary in mediation and arbitration?
Okay, this is a sort of a compounded question. I'll try to answer as the best as I can. Arbitration is a way to solve disputes that is a sort of formal, okay, is followed by the law and usually is regulated by the Code of Civil Procedure of certain country. As such, arbitration does want parties to be assisted by lawyers, okay? And unlike mediation, where sometimes mediation is not necessary to have lawyers, okay? In Italy, for instance, if you have a mandatory provision, then the law calls for a legal representation of the parties, okay? But again, there are rumors that say that probably there could be some exceptions to this legal provision in the sense that, for instance, where you have consumer for small or very, very small cases, small in terms of money at stake, it would be overwhelming to require the consumer to be assisted by a lawyer because, of course, the fees for the lawyer would overcome heavily the amount at stake. And so in that case, there were judges in Italy who applied to European Court of Justice, and the European Court of Justice said, well, okay, probably you are right, and say, let's open up an exception in cases where you have a consumer on one hand and a business entity on the other. Let's say that in that case, the consumer would not be obliged to be assisted by a lawyer in order to provide, I mean, a sort of an equitable way of handling dispute. Otherwise, he would spend too much money. And of course, he would come out and would have a sort of non-applied justice in his case. Did I left something?
No, I think that's fine. I think, can we go to Pietro? Is it okay to go to Caroline because she's had her hand up for some
No, there are
time?
lots of questions still in the
Yeah.
chat. Caroline, please type yours in the chat as well. I think-
Okay, all right,
yeah,
thank you.
yeah.
All right, so the next, do you want me to continue a bit longer, Pietro, with the questions?
Yes, please. And
Yes, okay.
Richard and Federico, if you could be more direct, there are quite a bit to cover. Yeah.
It's a
So-
yes and no. Okay.
So,
Okay.
Federico, sometimes, especially in Africa, there's always interference and influence on a party not to agree with the outcome. That's not favorable. What next?
Go to court.
Right.
You asked me to be direct, Pietro, okay? So
Yes,
Yeah.
that's excellent.
short answer, go to court. I mean,
What method can be adopted to ensure the conflicted parties trust the arbitrator? Because in a state conflicts, how best can the mediator ensure the safety of the parties?
well, that's a good question. Sometimes the mediator has not its own police forces, okay? So it's up to the parties to set up a sort of a safe environment. And sometimes that's difficult, okay? It's not easy. I know that there are a lot of examples of mediations that were handled where there were warring parties, okay? In Africa and elsewhere. For instance, in Northern Ireland, okay? And the rule number one is to provide a sort of safe space for parties. Sometimes the mediator has the weight to convince the parties or their representative to agree on a certain place for a certain time that would be protected by third-party influence in order to let all be able to speak freely and without much interference. But sometimes it is easy to to obtain, some other no. It depends. Okay.
Right. I think you've answered this, but it says, what is the time frame for ADR? But you did say it varied considerably.
Yeah, it varies a lot. It can be a few hours for a mediation. Formally, in Italy, for instance, we prefer to have at least to provide the parties with at least 30 days. And of course, if the sooner the better. If the parties want to settle first and before the 30th day, fair enough. But the point is that the parties should retain control over the length of the mediation. So as such, if the parties feel jointly that they need more time, then they should not be barred from a provision to proceed even further on. Okay, so it's up to the parties to decide whether 30 days is enough or if they need more time. Okay, this is similar to arbitration, with the only exception in arbitration, it must be crystal clear the end time for the arbitrator or the arbitrators to issue the final award, because it's the only legal way to go after the arbitrators if they do not comply with that obligation. Okay, it's the only obligation they have. If they want to be paid, they have to issue and render the award in a timely manner. So sometimes it's difficult for the arbitrators to do this in time, and humbly ask the parties to allow them with more time. Sometimes the parties say yes, sometimes the parties say no. Okay.
So this is a good question. In the case of two parties, hot-tempered, don't want to come together, what next? What is the solution to that one?
Interesting. I would like to ask, of course, why those parties will not to talk together, but there are two possibilities. Either one or both of the parties appoint a proxy, someone who is capable to handle and to deliver what that party has to say at the negotiation table, or the mediator can embark in so-called shuttle mediation. So the mediator is there to move from one party to the other, and when authorized, convey requests, options, etc., that come out from the single dialogue with each of the party. Okay, this is the typical case that occurred when you had the 1968 the agreements. The Camp David agreements, okay, between Egypt and Israel, okay, where the Americans acted as, let's say, mediators, and they were there to go shuttle because both representatives of two countries didn't want to talk to each other for political reasons, okay? So only after they reached the agreement and they had to sign that, there was the possibility to the picture time that figured out them along with President Jimmy Carter there and shake their hands, but only at the very end. So the entire negotiations occurred indirectly with the assistance of the actual assistance of the Americans acting as mediators. Okay.
This next one, I think you've answered. About the enforcement of the binding agreement. What if one party refused to abide by the agreement? What happens? I think you said go to court.
First of all, go to court, and in some countries where is provided by law that the settlement agreement is directly enforceable, you go to the court's clerk and ask for immediate enforcement.
What do you do if there are signs that the mediator's taken sides or shown interest in one party rather than the other?
Raise your hand and say, Mr. or Mrs. Mediator, please step out. I don't trust you anymore. If you feel the mediator is losing his or her third-party character, her neutrality, then it's probably better to ask for a resignation of that mediator and get a new one.
This is interesting. Can the parties explore ADR more than once? I'm guessing not for the same dispute.
Not necessarily. I had examples there is, apart from, there are even more sophisticated dispute resolution clauses that you can see in international contracts, where you have a med-ar-med kind of disputes. So you have mediation first, then you have arbitration, then the arbitrator issues the final award, but do not disclose that award, because at that time, a new mediator will step in and let the party try to mediate. Just to provide the parties not only with a day in court, but especially with opportunity to have a sort of full-fledged litigation. And instead of having an award that would decide who is right, who is wrong, at that time, the parties would be probably more willing to try to find a mutually agreeable settlement.
Who identifies the mediator?
Good question. Usually the parties jointly, okay? Sometimes it happens that one party go to a mediator because it's well known as such, and ask the other party whether she wants to agree on the appointment of that mediator. By the way, both parties have to pay the services of a mediator. More commonly, especially in nowadays, parties, instead of choosing or selecting their own mediator for the single dispute, they go to mediation providers like the Chambers of Commerce, LCIA, or CEDAR in London, etc., that are specifically devoted, dedicated not only to provide mediation services, but also they maintain a roster of mediators that can be, scrutinized. They maintain their own web page, picture, resume, etc. So it's more convenient for both parties to choose the best.
So I think this will be the last question because I'm concerned about the time. I'm sure
Yes.
Pietro will be poking me as well because we've got to hear from Zephaniah. What is the best ADR strategy to use in resolving family conflicts?
Oh, family conflicts, you said?
Family conflicts.
I would say, well, it depends a lot on the kind of conflict, because family conflict is a large concept, okay? You can have only wife and husband, you can have children of a certain age, different children from different unions, etc. So it's different. It's very, very composite. But on average, I would say that mediation can have a say. Okay, in the sense that a skilled family mediator, especially one who has been trained as such, not as a civil and commercial mediator, rather as a family mediator, can really provide some substantial help to the parties to reconnect their relationship, okay? Because don't forget that unlike the civil and commercial mediator, family mediator is not there to help parties find a solution. The family mediator is there to help parties rebuild their relationship and provide a new basis, a more effective relationship and rapport between the two, the husband and wife. Okay, so a different. Okay.
So Pietro, do I pass this back to you now?
Yes, please. Thank you so much, Alison, and special thanks to Federico for that beautiful, wonderful presentation. We could go on and on. The questions are just trooping in. PDG Alison, please confirm that we have the chat being saved as well, so that I could forward the questions to Federico, and he can provide answers that I will share with the audience later on.
I will
Yes,
love yes.
I've saved the chat.
Okay, beautiful. Thank you so much. Rotary and Federico, thank you once again for this presentation. We appreciate you. Okay, please, I would advise that we name our Zooms properly. I'm seeing some device names: Infinix Hot 12, Xiaomi, number. Please recall that this is being saved and will be referenced with your grading in terms of attendance, and will not accommodate when you say that was me, though is your device name, because many people can claim that. That's just a reminder anyway. Next facilitator on our schedule, I will be calling him up shortly. Sorry, we crept a bit into his time. Be that as it may, we didn't also start on time with Rotarian Frederick, but I'm sure we can accommodate a couple additional minutes to Rotarian Zephaniah. With that said, very distinguished ladies and gentlemen, it's a pleasure for me to introduce Rotarian Zephaniah to you. Rotarian Zephaniah will be taking the module on practical approaches to grassroots community groups and third-party conflict resolution.
We've got some interference.
Yeah, it's raining surprisingly over here, and
Could everyone just check they're muted, please?
Done.
It might be Seth.
is it better now?
Yes, no, Seth. Oh, I think it's Zephaniah.
Okay. Oh yeah. Okay, while it's sorting that out, Zephaniah, please check if there's a device that is interfering with yours or something. Maybe a radio frequency is interfering. Okay.
I just muted you, Zephaniah, just because to stop the noise. Forgive me. Have a look and see if you've got anything else. So Pietro's saying, Zephaniah, have you got any radio appliances on nearby? No, nothing. Zephaniah, do you want to go out of the room and come back? Let me try that. Leave the
Yeah, but
meeting
he also
and come
needs
back.
to not just go in and out, close the Zoom application entirely when
All right.
you leave, and then open it afresh.
Did you hear that? Okay, close down and open up again, and we'll wait for you. Maybe while we're waiting, would this be a quick comfort break for everyone, Pietro? But 2 minutes only?
My experience with that, Alison, is that
No,
once
they won't come back. All right.
they won't
Shut
come
up,
back.
Alison.
So I think I'll have to take Zephaniah's bio in his absence so that once he joins back, he will get right
Okay.
into it.
Because remember, we've got a 1:15 meeting.
Yeah, exactly. Okay, so Zephaniah will be taking a module on practical approaches to grassroots community groups and third-party conflict resolution or mediation. So his responsibility is to bring what Rotarian Federico has taught us in the past 1 hour to life, to practical sense, so it can make more sense and be more relatable. So Zephaniah Moshonge is a chartered mediator accredited by the Institute of Chartered Mediators and Conciliators of East Africa, ICMC, and an advanced trained mediator certified by the Mediator Training Institute International, East Africa, MTI. He's a certified professional mediator accredited by the Kenyan judiciary. Additionally, he holds an executive mediation and negotiation certificate from the Africa Center for Collaborative Dispute Resolution, Ghana. Mr. Moshonge is a specialized banking and insurance mediator trained at Strathmore University, Kenya, and has earned further certification from the German Foundation for International Legal Cooperation, IRZ, African Mediator Association, AMA, International Mediation Institute, IMI, Singapore International Mediation Institute, SIMI, and the World Intellectual Property Organization, WIPO. As an elder in the Alternative Justice System, AJS, under the Kenyan judiciary, Mr. Zephaniah plays a vital role in grassroots dispute resolution. Academically, Mr. Moshonge holds a postgraduate degree in educational psychology from Jaramogi Odinga University of Science and Technology, and a bachelor's degree from Moi University. He has served as an adjunct lecturer in psychology and is an experienced educator in English and literature. Currently, he serves as the Director of Public Relations for the Rotary Club of Kisii Central District 9212. Also, he served as board member of the Institute of Chartered Mediators and Conciliators of East Africa from 2024 to 2025. His leadership and dedication to peace building have earned him an international award in transformational leadership from Change Nations Mental Real of States in 2025. Ladies and gentlemen, I am most glad to present to you Rotarian Zephaniah Ongera Moshonge. He's also a positive peace activator. Please, my Rotarian, you have the floor. My Rotarian, can you remove the earpiece? Can you unplug the earpiece and talk to your device directly? That's it.
Can you hear me now?
Exceptional.
Yes.
Good, sir.
Thank you. Thank you.
Pietro, you need to stop sharing perhaps for Zephaniah to share.
I apologize that I'm on call from the western part of Kenya, and the network here is fluctuating. So if I break, kindly, when I drop, it is not intentional. Please bear with me. I want to thank the organizers of this particular training. I'm heavily indebted to all of you for your attendance as well. Allow me to join without my camera, kindly. So I want to ride on the introduction that has already been done by Professor Federico Antich and proceed to speak on this topic on practical approaches to grassroots community, group, and third-party conflict resolution, into brackets mediation. First, a mediator should be that individual who is a neutral, a third party who has undergone a 40-hour training, to say the bare minimum, an individual who is willing to cooperate with parties and facilitate them in seeking to settle their dispute. A mediator should also be controlled or guided by the code of ethics as provided by the law. Let me go through the basic characteristics of a mediator. If I repeat, it will be for purposes of emphasis. And again, I want to stress that I'll be riding on the presentation done earlier by Federico Antich. Professor has already indicated to us that mediation is a process that is tailored towards a settlement of a dispute. And so parties happen to be the key stakeholders in this process. Mediation revolves, therefore, around the parties concerned, by them highlighting their interests and communicating freely their desires. A mediator's role here will be to facilitate the parties by not gagging them, however, but by redirecting them and seeking to focus their attention on their interests and how best then to arrive at resolutions. Parties, therefore, are compelled to work out towards a resolution by exploring creative ways of resolving their conflict, still within the guidance of a facilitator here referred to as a mediator. Mediation is also a win-win process whose outcome does not by any way disadvantage any of the parties involved. Through collaborative efforts, parties are guided by the facilitator, here again referred to as a mediator or a neutral, who all the time guides the process towards a settlement if possible, by removing competition between or among the mediators, the parties, sorry. Confidentiality is a key element in mediation. Here, a mediator who has been trained and who abides by the code of conduct is under oath not to reveal the privacy, the discussions, or the challenges, and even the desires and interests of the parties involved to the public. Because if the public gets wind of the process, the public may have different desires and interests, and therefore may scatter the process of mediation. Mediation is a flexible process away from court, which therefore allows for the use of a language where the parties feel competent and comfortable to deliberate their challenges or conflicts. And this communication is done away from court. It can also be by way of shuttling or shuttle diplomacy, where mediators move from point A to point B if the parties cannot see eye to eye at the beginning of the mediation process. Flexibility of mediation also allows parties to choose their own mediators, especially in family mediation, where parties or family members may be uncomfortable to expose their story to certain individuals. Mediation is a process that is economical. Unlike other ADR and unlike other legal processes, especially litigation, and to some extent arbitration, mediation is cheap and highly cost-effective. In mediation, the fees might be within the reach of the parties as opposed to other processes of resolving conflict. In Kenya here, court-annexed mediation is done at a paltry 20,000 Kenyan shillings, roughly $20, 20 US dollars. That is quite cheap indeed. The resources that go into litigation are mitigated in mediation, especially in international matters where parties and indeed counsels require to travel and incur huge amounts of money. In mediation, this cushions the parties concerned, and indeed filing suits in litigation is lifted when parties choose mediation pathway. In Kenya, mediation is timed to last 60 days if it is court annexed, and therefore it is a timely intervention in dispute resolution. The process sometimes can take us short as a day or indeed a week. I've had an experience of settling matters within a day, and therefore mediation becomes very desirable when time management is key.
Sorry, please, my ambassador, am I on the right slide?
I'm doing an introduction. It may not appear on the slide, Pedro.
Okay, excellent. All right.
I will be there soon. Sorry, I didn't alert you.
Okay.
But please maintain on the first slide. In mediation, again, we do have agreements that are reached by the parties concerned, which are enforceable by courts, agreements that are not reached under duress, agreements that are reached by the involved and interested parties themselves, and therefore the agreements remain binding and are not appealable, since the parties could have reached this settlement in good faith, and therefore a possibility of a party reneging on the contract is minimal. However, should there be any interest by a party to appeal or another member of the public for whatever reason, then the process can be reviewed, but under very strenuous conditions indeed. Also, mediation requires not necessarily any other party, such as the councils, except where it is mandatory. Otherwise, the presence of councils or advocates remains advisory, and therefore it does not direct the course of mediation. Pedro, thank you for waiting on call. Allow me to move to the first slide. So conflict is inherent in humans, and therefore there is need to focus on how effective to resolve conflicts so that we maintain peace and social harmony, especially at the grassroots levels. In many communities around the world, including grassroots conflict resolution mechanisms have remained paramount in addressing disputes before they escalate into a larger conflict. Noteworthy here is the fact that communities at the grassroots, this is where so much action happens, and therefore it can be as packed. A community as minimal as having members, say 10, having a dispute may escalate to international proportions depending on the nature of the conflict. The core focus of this presentation is the various aspects of the grassroots conflict resolution, the historical contexts and the strategies where mediation is practiced, the challenges in conflict resolution with a specific focus on the Kenyan and South Sudan jurisdiction, and various mediation approaches and involvements around the world. The conflict resolution and mediation used as a tool for peace building and cohesion among societies, the relevance in Africa's diverse communities, and the multicultural dispensation that we experience. Next slide, please. objective of the presentation is basically to explore the practical approaches in conflict resolution and the mediation process. In a number of dispensations or jurisdictions, we have court annexed mediation, where I have practiced for the last 8 years, where a matter is referred by court to the mediator. And the language used here is outside of court settlement or negotiations, where depending on the nature of the matter, in the wisdom of the court, a case may be referred to a panel of mediators or even a mediation center, and indeed a specific mediator, where a number of us appear on the role of the mediators of court, and therefore, depending on the competencies and experiences, different mediators process certain matters are therefore referred for mediation to them. And once done, the matter or the file is returned to court within 60 days, with updates being presented before court at specific moments. There are 3 possible outcomes in this region. Parties can agree, that is, parties can reach a full settlement agreement. Sometimes they can have a partial agreement where 1 or 2 issues are resolved, with others remaining being referred for determination by court, or they can have a non-settlement where parties fail to reach an amicable resolution, and therefore the matter is referred for litigation, and the process of litigation commences or
Sorry, my
proceeds.
ambassador, please, can you confirm that I'm on the right slide, please? Are you seeing this slide?
Hello, Pedro, can you hear me?
Yes, I can hear you.
I'm on the historical context.
Okay, am I on the right page? The slide, am I showing the right slide of where you are?
Yes.
Okay, excellent.
You are ahead by some. Could you please look at the historical context?
So am I going to the front or back? Okay, this.
Yeah, there you are. Thank you.
Okay, thank you very much. Okay.
Sorry, here the network flickers.
Okay.
So historical context of mediation in the African context is that traditionally African societies relied on consensus building and dialogue to address emerging issues. And therefore, elders or clan leaders and spiritual mediators who were selected played primary roles in seeking to resolve matters or conflict affecting members of such communities. In Kenya, we have examples of the Njuri in JKF, the Ameru community, the Luo Council of Elders from the Luo community, and the Abagusi Council of Elders, who were discharged with restorative justice. Worth noting here is that the elders needed to have met certain bare minimum conditions for them to be eligible to preside over such conflict resolution mechanisms as elders. Next slide, please. The grassroots conflict resolution scenario At Grassroot, and this is where a number of us work as Rotarians, as peace ambassadors, and as positive peace activators. Communities are engaged to address disputes that emerge, and oftentimes these disputes are handled informally. However, they are deeply rooted in cultural traditions, and therefore each community has a cultural background against which mediation is conducted. An example has been given above, and the Nyumba Kumi initiative is the most recent initiative in Kenya. Group, next slide, please. Group conflict resolution. It's also possible that mediation can be done by more than one individual, and so it is themed group conflict resolution, which targets conflicts within a structured group, such as organizations or even clans. And here, mediators use collaborative approaches like dialogue in circles, we have negotiations. And so an example from our community here in Kenya is again the Jurinjeke, or even the clan elders of the Abagusi. These groups are given the conflicting parties, or they are presented with the conflicting parties, and sometimes a conflicting party may appeal to them for hearing. And once they are convinced, it is a matter that requires to be heard. So a meeting is called and the process of mediation ensues. Next slide, please. Third party mediation. My predecessor, Professor Federico, has already gone through third party mediation in a few of his examples. This is where independent mediators, trained and professionally certified, or organizations that have been approved, facilitate discussions. These organizations or mediators focus on some of the characteristics, and indeed all of the characteristics of mediation, such as being neutral, being fair, and being non-judgmental, and also not offering solutions per se, but guiding parties towards a settlement. An example is the IGAD, Intergovernmental Development in Africa, which had a role to play in the South Sudan peace talks. Just recently again, we had one of the dignitaries from Kenya, the Right Honorable Raila Amolo Odinga, proceeding to mitigate conflict, albeit with little success. In Kenya, next slide, please. In the Kenyan scenario, we have quite a number of conflicts, among them land disputes, ethnic tensions, political differences. We also have family issues or family conflicts. We have criminal conflicts and so many others. But the most notable ones that have attracted international attention are the ones cited above. We shall discuss them as time goes by. Next slide, please. There have been challenges across nations, especially where parties or countries or nations have had differences on resource use, like water masses. We have had tribal clashes or conflicts on the borders with different communities. We've had political instability in a number of African countries, both internally and sometimes externally. There has been a number of success stories recorded by such organizations as the ECOWAS in West Africa, the Economic Bloc of West Africa, and I know Nigeria has been a beneficiary of this kind of organizations where organized bodies have restored peace between or among conflicting parties. Next slide, please. Despite the good stories around mediation, there have been a number of challenges at Grassroot, one of them being limited financial and human resources, which is why this call was organized so that we can, all of us, share information and retool our approaches towards an empowered peace-building body which can restore peace across the globe so we can make this world a better place to live in. Financial constraints notwithstanding, mediation still has a role to play. There has been resistance to external interventions where some communities feel there is lack of goodwill from the participating parties, and sometimes mediators or even organizations which appear at the mediation table with vested interests, be it financial or even political. And so that makes mediation a not so good option to a number of grassroots initiatives. Next slide, please. There are also challenges concerning group mediation. Deep-rooted mistrust among conflicting parties, where a good example is given of South Sudan, where some parties or one party feels the mediator is already identifiable or even biased towards one party between the president and maybe the first vice president. Leadership struggles and power imbalances across the region also have marred mediation processes where certain individuals are perceived to be powerful and therefore influential in the outcome of a mediation process. Therefore, some parties feel they will not achieve or realize justice through such processes. Next slide, please. There have been challenges also in third-party mediation where potential biases and perceived lack of impartiality, as I've mentioned earlier, are recorded. The most recent example concerns the Right Honorable Raila Amolo Odinga, who was not able to access parties in South Sudan because he was perceived to have had a bias, and therefore the process could not take off. Political pressures also impacted some outcomes where certain very influential members of the political class would wish to have mediation biased or tailored to suit them. And therefore, this becomes a big challenge. Occasionally, international organizations are accused of having a hand in some of the conflicts. And therefore, when they present either themselves or they nominate a certain mediator or organization, this is met with opposition, and therefore mediation collapses. Next slide, please. I have in my presentation mentioned South Sudan quite often because it has for a long period of time been involved in quite a number of internal wrangles or conflicts, and Kenya has hosted or played host to a number of our neighbors. The Vice President Riek Machar would not discuss anything internal conflict affecting his country because he perceived the Right Honorable Raila Odinga as having a hand or a bias in his mediation intention, and therefore he was turned away and instead referred to discuss this matter with President Yoweri Museveni of Uganda in this regional conflict management. Next slide, please. There are a number of strategies that have been engaged at the grassroots level to give mediation teeth. And one of them is to leverage the cultural norms and values. Every community globally has its moral structures, and therefore communities, they know themselves, they understand where they're coming from, they know their story. Therefore, when a mediator comes from within a given community or learns the culture of the people, it becomes easier for that mediator to communicate with conflicting parties and facilitate them towards a settlement. Culture also entails language. It becomes easier when a person who speaks a language of others speaks with them with all the idioms used, and that brings some level of affection. But this is not to say a mediator should be Hello, I'm breaking. Hello, can you hear me, Pietro?
Yes, we
Yeah,
can
you're
hear you.
fine. You're fine.
Sorry. So that is not to say, however, that a mediator should be that professional who has an emotional attachment to a matter. However, it only means that someone can relate with the conflict at hand, and therefore, being one of them at the grassroots, it becomes easy to agree or to accept a mediator, to agree with a mediator or accept a mediator because of that leverage. Enhancing local capacity through training, like what we are going through, is indeed another of the strategies to capacity build mediators so that mediators continue to learn the dynamics, they continue to acquire as many skills as possible, and also to learn stories from other mediators across the globe. And so they get encouraged more, they get revitalized, and they also become more engaged. Therefore, it is easier to achieve peace through that kind of networking. And sometimes where mediators feel inadequate, through such capacity building and networking, they are able to pick one or two co-mediators with whom they can facilitate peace building. Another strategy is to build communication channels. Communication channels like open pathways, including correspondences, using language that is non-judgmental, using platforms that are free of bias, using certain spaces that don't judge, and opening fora where parties can freely share their challenges or their problems. Trust is built, and therefore mediation becomes agreeable and acceptable by many parties, hence facilitating peace. Next strategy is encouraging shared decision-making process. It is also important to consider having a team spirit where parties don't feel like they're left out, parties feel involved, where gender, where age, where region, where religion, all of them do not have a big consideration. Rather, what makes sense during mediation is a conflict and not the focus being shifted to the parties involved. Therefore, when parties focus more on the problem, they're likely to reach a settlement, and therefore decision-making process becomes a team or a shared process, and therefore it becomes easier. Just like it has been mentioned earlier, once involved, parties are able to therefore implement that which they agreed. Next slide, please.
We're
Please, my
experiencing
ambassador,
sound
I think
difficulties.
another device is on at your
Someone
side.
should
It's
mute from
bumping.
his end or her end.
Sorry for that. It has been effectively mediated by many of us, and so now we are on.
Okay, thank you, sir. Please, you have 5 minutes more.
Next slide, please, on the
Yes.
strategies for third parties to emphasize on confidentiality and trust building. Just like we have said, it becomes easier to accept a mediator whose background, just like Professor Federico said, you have knowledge about his or her input, and someone can comment about his ability, and therefore someone is in good standing because he is in compliance, he is obedient to the code and has observed the code of conduct of mediators, has no violation whatsoever, and therefore such a mediator is easily accepted. Next slide, kindly. Women are assumed to be peacemakers, homemakers, and therefore women, because of their engagement in many societal activities, they promote reconciliation much easily. It is argued because women carry a lot of responsibilities at family and community level. Next slide. The role of the youth in mediation cannot be overemphasized at Grassroot. The youth are largely agents of change because of their energy, because of the youth are savvy, they are creative, they are more innovative, and therefore when they are used well through drama, when they are used well through peace campaigns through football matches, through athletics. It is argued that mediation is achieved very easily. A case in point in Kenya is the athlete Tekla Lolupe. Tekla Lolupe has been the star around mediating conflicts among the Kalenjin people. And she has initiated a number of projects back home through her foundation. In mediation, what we're using currently, Zoom and such other platforms have enhanced communication, and they have made mediation processes become easier. Indeed, a number of us are now mediating online, and a lot of learning takes place online. Mediation can also be accessed much easily through such platforms. And indeed, the use of technology can also be used to map out certain spots which require mediation. Next slide. Thank you, Pedro. You'll give me just 2 minutes. There is a legal framework in Kenya, just like it is across many countries in Africa. Here in Kenya, the law provides that alternative justice system, particularly mediation, which has been made as an act of parliament, allows for justice to be served through such process. And therefore, whatever agreement parties reach is binding, therefore enforceable by law. This is also found in the Arbitration Act and the Constitution that was promulgated in 2010, which therefore gives alternative pathways to resolving conflicts an upper hand. Next slide. Thank you. The legal framework in Africa can also be found in a number of dispensations across your country, Nigeria. Ghana has its fair share of this legislation. South Africa just the other day pronounced itself to a possibility of giving mediation first priority to unlock the so many cases that have been in court for many years, thereby denying citizens their justice. Next slide, Rotarian. There have been many lessons learned across Africa and indeed the world where conflicts have been resolved. We are reminded of the Kenyan experience in 2007 when the late President Mwai Kibaki had a political difference with the Right Honorable Raila Amolo Odinga. This took the intervention of the eminent persons from Ghana, the then president, retired president of Tanzania, Jakaya Kikwete, Kofi Annan from the UN, among other dignitaries who helped to resolve the political tension, hence peace. Next slide, please. The role of government and NGOs, non-government organizations, has also been experienced, and it is very well documented in peace books in Kenya, where they have brokered peace across borders and indeed within the country, and even within the continent, where dialogues and mediation programs continue to including what we do in Rotary, including what we already do as positive peace activators. And we owe this to the Institute of Economics and Peace. And these are some of the organizations that have come out to support mediation and indeed peace. Next slide, please. The next, please. The next one, I'm finishing. Thank you. Community empowerment. It is encouraging to note that community of resolution efforts make mediation first preference because it promotes inclusivity, fairness, and participation. Therefore, settlements reached out of this process are long-lasting, if not permanent. Next slide, please. Adaptation of the cultural sensitivity and indeed the use of nonviolent communication as it is embodied in Africa makes mediation a very significant contributor towards efforts. Of countries in Africa regard traditional leaders and indeed traditions as a whole as being the binding factor. And so many people state toward their cultures which prohibit violence. Many cultures in Africa, if not all, prohibit divisiveness, and therefore there is need to engage in mediation processes. Next slide. Collaborations by a number of organizations, governments, individuals, and communities, including Rotary, has played a key role in mediation, in peace through the project, through dialogue, and through conversations around peace by preserving the environment, provision of water, and every other activity is engaged in. They have to be a big towards mobilizing communities to peace. Last slide, what are the recommendations arising from this? We are encouraging grassroots initiatives to scale up the multiplier effect. If we could have a number of Rotary clubs, if we could have a number of and actively involved IAP practitioners, peace promoters, we would achieve peace within our continent and beyond by promoting peace education, skill, and usefulness of harmonious coexistence will be achieved among the people of the world. This peace education can be realized in all of worship, if not a number of the learning institutions, and indeed wherever assemblies are, where individuals could be found and stories around then would be shared, where world peace would be no longer a dream, but a reality. My conclusion, last slide, please.
Are you on the line, Pietro?
Yes, I think
Okay.
we've lost
Our
Ambassador.
next meeting is here.
Hello, yeah, I'm here.
Hi, Peter. We're just closing.
It's
Oh, my
okay.
PDG. Sorry, we'll soon round up. It's nice to see you. Ambassador Seth, we can't hear you.
We've lost him.
Yeah, I think it's network, like he informed us earlier.
Mm.
Okay. Please let's input our questions in the chat box. Once he rejoins us, PDG Allison will be taking the questions so he can quickly respond to them.
No, Pietro, we have to close. We have to now turn to Peter. Sorry.
Okay,
So
I
if people
agree.
put their questions in the chat, we can
We'll
perhaps
send it to him, right?
on. Yeah.
Okay, that's fine. Very distinguished Rotarians, thank you for your time and apologies. We were scheduled to close by 1 p.m. Unfortunately, we didn't start at 11 a.m. as intended due to technological hitches. And we had to do some time spilling over, and here we are. We have another meeting scheduled with a very high-ranking Rotarian, PDG Peter King, for 1:15 p.m. and he's on the call with us. With that said, we thank you very much. Today's session has come to an end. Your questions will be sent to Rotarian Zephaniah via email, so he can provide responses in via the same means. We will share those correspondences with you together with the training materials as well. So thank you very much for your time. Tomorrow is same time, 11 a.m. We'll be having 2 facilitators on strategic communication and the other one as well. Please join on time so that we can finish as scheduled. With that said, it's a pleasure to inform you that today's session has come to an end. Thank you very much and enjoy the rest of your day. Bye.
Thank you.
Thank you.
Bye-bye.
Thank you.
Thank you very much.